Military parole in place. This is an option for United States citizens who have undocumented parents or an undocumented spouse or children in the United States. Let's say your parents, spouse, or children under 21 entered the United States illegally, commonly known as entering without inspection or EWI, meaning they were never inspected or admitted legally into the United States. Then even having a U.S. citizen child who's 21 years or older will not lead to legal status or permanent residency. That 21-year-old child can file the petition for the parent, which is the first step, but the second step, which is the residency, cannot occur. However, if that U.S. citizen's son or daughter is willing to consider enlisting in the armed forces, then there is a possibility. Likewise, if a U.S. citizen has an undocumented EWI spouse, then without a legal admission, that spouse would have to undergo a complex waiver process and leave the United States for a consulate interview and conclude their case overseas. Now, a U.S. citizen can enlist at 18 years old. The legalese of military parole in place can be found in the USCIS Policy Manual, Volume 7, Part B, Chapter 2. It states that military parole in place may be considered for certain family members of individuals who are serving an active duty in the U.S. Armed Forces or selective reserve of the Ready Reserve or who previously served honorably. Now let's break that all down. Firstly, that means current and former members. Now, if it's a former member, that is a veteran, must be a normal discharge. It cannot have been a discharge or other than honorable or a dishonorable discharge. Secondly, what qualifies as U.S. Armed Forces? That definition can be found Volume 10 of the United States Code, Section 101A4, 101 is always definition, which includes Army, Navy, Air Force, Marine Corps, Space Force, Coast Guard. So that's 6 so far. In addition to those 6 branches of the U.S. Armed Forces, there's also the Selected Reserve of the Ready Reserve and the National Guard if they were federally recognized or called into federal service. So that means there's 8 options total. Merchant Marines don't qualify for military PIP. Now, how are family members defined? That's a spouse, widow or widower, parent, son or daughter. So if you are in or were in one of those 8 qualifying U.S. military branches and you have a spouse or, God forbid, former spouse that passed away, or son or daughter that's not in legal status, this is an option for you and your family members to get those family members permanent residency or a green card. Basic training with many of the military branches can be completed in as little as 3 months plus or minus, and then once you have that DD-214 or LES, then the process can begin. Few very important things to consider. Firstly, while an 18-year-old can enlist and file that first step, that military PIP, on Form I-131, they have to be 21 years old for the petition, which leads to the adjustment of status. So do you wait or what do you do? Well, the military PIP, if it's approved, your family member qualifies for a work permit, social security number, which all makes it easier to get a driver's license, bank accounts, buying real estate, a home, a toehold in the economy, and much, much more. Also, if there's another sibling who's already 21 years old, even if they're not in the Army or armed forces, they can petition, meaning the 18-year-old can do the military PIP and the next relative can do the next step. Do talk to a qualified attorney for this.